Hi, my name is Nicole Hemrick, and I'm the managing attorney here at Hemrick O'Malley, PLLC, located in New York City. Today, I'm excited to talk to you about one of my favorite visa types. That is O-1 visas for persons with extraordinary ability. Now, we have handled O-1 visas successfully for people in all different industries. In terms of the O-1B artist category, we've worked with models, actors, graphic designers, musicians, opera singers, movie directors and writers and producers, creative directors, and interior designers. In terms of persons in the O-1A category, which could be either athletics or business or education, we've worked with people who are software engineers, CFOs, tennis pros, golf pros, persons in the wellness industry, persons in the hotel industry, real estate moguls, media marketing specialists, and persons who are in higher education. The question typically comes up whether people in the O-1 category can self-petition and whether they can freelance. The answer is not exactly. You do need a sponsor, and the sponsor does not necessarily have to be an employer. USCIS has provided for a situation where there can be an agency relationship for purposes of sponsoring in the O-1 visa category. Now, when people hear the word agent, they think, oh no, I need to get a talent agent. That's not exactly right. Your sponsor might be a talent agent, but when USCIS permits agents to file, in this sense, they are talking about a person simply acting as the sponsor to sign the immigration paperwork. That is the forms and the petitioner letter, which is essentially the letter that describes all of your qualifications. Besides being a talent agent, this agent sponsor could also be one of your potential employers, or it could be somebody that simply is a U.S. citizen and is willing to sign for you, or it could be a representative from a business in the U.S. that is willing to sign for you. I have handled matters in all of these various scenarios. Now, can you freelance? Well, USCIS doesn't like the word freelance, but what you can do is, in this situation where you have an agent petitioner, you could have multiple employers. And what that means is that you would present letters of employment, or if you're in an industry where there are deal memos, a deal memo or multiple deal memos outlining the scope of your work and when that work is expected to take place. You'll want at least two of these. If there aren't at least two, then it should just be direct employment, and you're not going to have this ability to work with multiple employers, and it should be just your direct employer filing for you. If you are going to be doing an O-1 visa with an agent and you're going to be having multiple employers, a great thing is that in the future, during the 3-year period of employment, which is the maximum per O-1 visa, if you wind up being offered employment within your field of extraordinary ability that was not previously presented, that is okay. As long as it is within the correct field, you could still take that work. Another important thing in this sort of scenario is that there will have to be an agent agreement between you and the agent, that is the person signing for you or the company signing for you for your visa paperwork. We have helped people to do these when such an agreement does not already exist. And again, since this is not necessarily a talent agent, there doesn't have to be any provision for remuneration to the person signing for you, although there can be, but it's not required. And the vast majority of the cases that I've handled like this, there is no such provision for remuneration to the agent. Finally, you want to make sure that when you gather your employment letters or deal memos, that they cover the full 3-year period so that you can maximize the time on O-1. If your employment letters or deal memos do not cover the full 3-year period, USCIS might not grant your O-1 for that period. They could look at it and reduce the amount of time just to cover the work that's outlined. If you have any questions about O-1 visas or any immigration matter, feel free to contact us at 833-848-7838.